Yes, Mr. Banerjee.
Item number 1 and 2.
My lord, I was making a humble prayer before your lordship takes up 1 and 2 because they will, of course, take the day. Item 3, where I'm also appearing, an inquiry report has been filed by the state government, so the matter can be fixed for hearing. So your lordship kindly gives a date for hearing in item 3, and then I'll start.
In this matter, my lord, I am appearing for the petitioner, your lordship. My lord, as per your lordship order dated 8/5/2025, my lord, your lordship directed the state government to conduct an inquiry and give us an opportunity of hearing. My lord, they have conducted inquiry unilaterally. They have not given any opportunity to us. Although the inquiry report conclusion is against us, but report is in our favor, your lordship.
Very well. Then lordship hears it, my lord.
You are appearing for whom?
For the petitioner, my lord.
Please remind us of the matter.
My lord, matter relates to my lord, respondent number 7, who is cement manufacturing company, your lordship. They are engaged in the business of manufacturing cement using limestone, and they don't have license for mining limestone, and they avail subsidy amounting to rupees 200 crore, more than 200 crore, my lord. So, my lord, this is the matter. They admitted that a limestone license was taken in the year 2023. Prior to that, they are saying, my lord, that they have purchased from outside.
Mr. Banerjee is representing the company.
Yes. This is all, my lord, I'm not going to answer all the details here. All factually incorrect.
Inquiry has been conducted by the...
Yes, inquiry has been conducted. The report has been...
without giving me opportunity of being
all this aspect has been covered.
all has been covered is between your lordship. PIL is between your lordship and my lord, the party. The lordship will hear it and decide.
You were directed to be given a hearing.
My lord, your lordship directed to give me hearing in inquiry, but they have not given.
All right, let the report be taken on record.
My
lord. You take exception to that report in that
That's right. Lordship fixes a date, my lord.
Where is the report?
We have filed.
Because there is allegation against state government also, my lord. Inquiry
Where is the order?
Where is the order, brother?
8/5/2025, my lord.
Where is the order? Where they asked to give a report. Where is that order?
Yes. Last para, my lord.
Necessary parties are those against whom the allegations is made.
And I am the party who had alleged. I have been, my lord.
Ultimately, matter between your lordship. If your lordship finds this a breach of the law, your lordship will take steps. Lordship will go into the inquiry report. My learned friend has his, whatever objections he has, he can put in his exception. Your lordship will consider that.
Will do.
As your lordship rightly observed, let him file his exception and your lordship takes it up.
My lord.
Simple question, capital investment, transport subsidies, both are clearly covered by the scheme. Limestone license, limestone was not even required prior to the amendment of the concession rules. I'll show all that to your lordship. I was thinking of 25th. Is it okay by you?
All right.
Please check.
Right.
My lord, if it commends to my lord, if it's possible, 25th July, the part, my learned friends have no difficulty. It's for your lordship, of course.
By that time, my lord, I will file my...
You can file his exception. If we have any affidavit, we'll file it also.
Order dated 19th February. Then instead of is alleged, right, was alleged. And second paragraph. Paragraph, this public interest litigation was admitted on 19th February 2025. Okay, in the first paragraph, after respondent number 9, you write Amrit Cement Industries Limited. By an order passed on that day, we directed the state to treat the petition. Anyway, instead of that, order dated 8th May 2025. Next, on 8th May 2025, time to make the inquiry and file the report was extended. Till 2nd July, and the public interest litigation directed to be listed today. The state has conducted an inquiry and a report has been filed in this court. Full stop. It is taken on record. Full stop. Let copies thereof be circulated to all the appearing parties, if not already circulated. Paragraph. Learned advocate for the petitioner seeks an opportunity to file an affidavit dealing with this report. Full stop. Such leave is granted. The affidavit may be filed by
20th of July 20.
20th is a Sunday.
Sunday. Monday 21st month.
Yes. When is your convenient date, Mr. Manager?
25th, my lord, I was suggesting. Subject to your lordships, my learned friends have been kind enough to agree, my lord.
Would it be 24th?
24th, my lord? 24th.
21st, list is public interest litigation once again on 24th July.
My lord, if my client wants to file an affidavit, they may also be permitted to do so. R9. Lordship can.
Any rejoinder to this affidavit in opposition may be filed
I am obliged.
by the respondent number 9 before the returnable date.
Obliged.
Deeply.
Your Lordship permission, my lords, I may mention a matter. My lord, this is a matter for fresh. This is a fresh application in a pending matter. I am requesting listing of the application tomorrow, my lords.
What is the urgency?
My lords, by virtue of your Lordship's order, this is for the additional bonded warehouse. So, by virtue of your Lordship's order, the bonded warehouse tendering process was complete, and thereafter, your Lordships had directed to produce the materials in sealed cover for further directions. So, my lords, if the bids will become infructuous if further directions are not.
So today we are hearing the matter.
Tomorrow, I am requesting, my lords, this application can be taken up tomorrow.
No, whatever is there, the contents of your application, You make your submissions at the time when this matter is being heard, and if necessary, we will give you leave to move it tomorrow.
Yes.
Just to clarify, my lord, the issue in my learned friend's matter is the second bonded warehouse, whether that can be permitted or not.
Yes.
Whereas the policy itself under challenge is whether even one bonded warehouse can be permitted. The main challenge which I am asked. Just to clarify. So he is having a difficulty with his tender in the second bonded warehouse. My lord, may I? Oh, I take your lordship to the papers. Just 5 minute
Yes.
quick, my lord, if I may be permitted. So if I may just recount in 5 minutes, the major challenges to the policy. And then what I had argued on the last occasion, just 2 minutes on that, and then I'll proceed further with that. So the policy of the government here is that a central bonded warehouse is to be set up. My lord, Mr. Shah has placed the notifications at length. I may do so if required. And the original procedure was that there were, and there still are for that matter, 45 bonded warehouses which are set up all over the state of Meghalaya. The manufacturer, supplier, my learned friends, clients, sends the stocks from outside the state, Haryana and elsewhere. They go to the they used to go to the bonded warehouses directly, and then from the bonded warehouses to the retailer. This, which is the shops where they are selling it to the customer. My lord, this was the previous practice. By the new policy, the stocks from the outside supplier now go to the central bonded warehouse, and from the central bonded warehouse, it goes to the other bonded warehouses, and then to the retailer. This is the new policy, which is under challenge. This is the substance of the matter. I will deal with the various challenges at length, but to summarize the challenges as I understand it, number one, and I will start with number one in detail again. Number one is that by reason of the implementation of this policy in the new CBW, I call it CBW in short.
You have said that they have been unable to show any legal injury.
Correct, legal interest. So the first bar is the legal interest. Because my learned friend has argued a lot on no statutory power, expresso unius, section 19 means you have got no authority. Then he has gone on to say on article 19 there is a private monopoly which is not permitted in law. Then he has gone on to say that under article 14 there are possibilities of favoritism by suppliers and bonded warehouses which are part of your organization. Various things have been said at detail. So all that will have to be dealt with, which I shall do so. But first, I had shown your lordship that before you complain about policy violations, which any citizen no doubt has a right to do, you have to show that you have been affected in some manner. And my learned friend was at great pains to show that by reason of this, I am now charging them an extortionate amount of 25% commission. Not me. The central bonded warehouse, I am the state, is charging them 25% commission. So now he has to, where he was given some much more reasonable commissions earlier, the central bonded warehouse is now a monopoly. According to him, since it's a monopoly, it can charge whatever margin or commission as you call it on all the supplies, and is charging 25% commission. May I immediately take your lordship to the letters on which my learned friend was relying. So if your lordship kindly comes to the writ petition, at I think 14 September 21, my lord, he has annexed various letters. Take up the letters. Yes, annexure B at page 11. Lordship has it, my lord? line bit. Just keep it there. Let me find it in my file. Got it? Just show me. 14th September 2021 of the petitioner, my lord. If your lordship kindly goes to that. Yeah. So this is from the bonded warehouse. Lordship has it?
1 minute.
8th April 21. Petitioner's affidavit, not the rate, right? This was shown to your lordships.
You only give the papers which are shown. Don't give all mass of papers here.
He has filed an affidavit on 14th September 21, and otherwise I can hand over my copy to your lordship.
No, it is here. We saw it last time. Seventh February, additional affidavit.
This is my lord, 14th September 21 of the petitioner company, Neeta Prannath Kapoor. In fact, the main emphasis of Mr. Shah was on this, that look at the extreme prejudice to which I am being just subjected. So this is very important, because this was the thrust of his case in the beginning, before he went on to some legal questions. 8th April 21, your lordship has it? Yes. So, we suggest paragraph 3, I'm not reading the whole thing. We suggest the paragraph 3 cost card should be finalized and should include 25% margin, which includes 8% bond margin. Well, my lord. At page 11, my lord, of that. 8th April 21.
Yes.
Yes. So third paragraph, we suggest the cost card, this is from CBW to them. Cost card should be finalized and should include 25% margin, which includes 8% bond margin. My lord, 8% bond margin is by law, notification. The bonded warehouses get that. Not CBW, the bonded warehouses. Freight, administrative, miscellaneous charges and CBW margin. So 25% is the total and includes the CBW margin. My lord, then, the next letter they have shown 9th April 21, similar letter from the central warehouse. Cost card finalized should include 25% margin. So these are another letter. Then page 13 is very important. Now kindly see page 13. To Bacardi. Regarding the confusion, my lord has it, my lord? 7th June, page 13. Regarding the confusion of 25% margin asked, we hereby clarify, out of the 25%, 8% margin is fixed by the excise authority for the bonded warehouse. This has been done for the first time, currently effective. This is something nobody has complained about, the bonded warehouse are getting 8%. The bonded warehouse has not said that they don't want 8%, my lord. They are getting this. Then you will appreciate the minimum 4% expenditure towards freight expenses. Infrastructure cost for setting up CBW is huge. Running expenses at 3%. Therefore, we are left with only 10% margin of the 25% proposed, which is again negotiable. Kindly note the word negotiable. Lordship has it, my lord? Negotiable. Which has been integrated. So this is a proposal. Now, the question is, what happened to this proposal? My lord, petitioners have proceeded on the basis that, look here, 25% is what they're charging us. Even if you leave out 8%, it is highly arbitrary, 17% margin on CBW. They are exploiting their monopolistic position, and this is because of this policy has given them this. This is the substance of the argument. And therefore, your lordship should intervene. Though in fairness, there were a concession, if you may say, on the later stages that if the policy challenge does not succeed merely on the basis of this margin, may not be legally possible to strike it down, but be that as it may. Fact is that this is the substance of the opening salvo. Now, it was necessary for Mr. Shah to establish this opening salvo because, as he was fully aware, unless your lordships are of the view that he has something to complain about, your lordship will not entertain further challenges, whether the policy is within the statutory power, whether there is a private monopoly permitted. All these fine academic questions will only come provided you can show the court that this is where the shoe pinches. And that's why I'm here. Now kindly, so this is the case. Now, therefore, your lordship would have to be satisfied, at least in the beginning, that by reason of the monopolistic position of central bonded warehouse, 17% margin is being extracted by them, over and above the bonded warehouse margin of 8%. Now kindly come, my lord, to the additional affidavit which we have affirmed on 7th February 2025.
No, last time it was.
What is the MP number? Miscellaneous case number? What is it? 1-3. Miscellaneous case 13 of 2025. Can you come to para 3, my lord? Oh, they haven't got it. Very well. Miss case 13 of 2025, affirmed on 7th February 2025. So there is no rebuttal to this, by the way. I mean, it appears. Well, it should not be because based on the state's records. Kindly come to paragraph 3. I would respectfully submit the entire basis for the petition that there has been some financial loss. That in itself goes, if this goes, The petitioner has alleged that creation of central bonded warehouse has led to the exorbitant trade margins being demanded by the central bonded warehouse. It is submitted that upon an analysis of the invoices and cost cards available by the department of various years, it emerges that CBW is charging no margin on various brands of liquor submitted by petitioner association. No rebuttal to paragraph 3. And we are not talking about a averment here, we are talking about the details which will come from page 9. Kindly see the chart. Since your lordship is fortunate enough not to be in any way connected with this concept of alcohol or liquor, unless some of us who have given way to temptation, your lordship may not be familiar with these brand names. So may I just indicate there are United Spirits there are Diageo and Pernod Ricard are two of the big players in the field worldwide, and they have various brands. Suntory, Bacardi, Campari, etc., William Grant Whiskey, various brands. So these from page, page 9 onwards, this chart which continues till page 21. This chart is very important because we have, state has examined on the basis of records given by the warehouse and our own record, what is the margin which is being charged by central bonded warehouse from petitioners. That will come at the second last column. Kindly see, very important, second last column.
Of page?
Of page 9. My lord has a chart?
Yes.
So the last column is the margin earned by the bonded warehouse. That is not in concern. We are not concerned with that now. That is fixed by law, should be around 8%. But that is not the challenge of Mr. Shah. Mr. Shah's challenge is on the CBW margin, which is the second last. Because his challenge is that exorbitant 17% margin is being levied by CBW, and it can be done because of its monopolistic stature granted by the policy, and therefore we agree by the policy. Point number 1 according to him. That is why he's coming to the court. As I said, this is where the financial loss, or whatever you like to call it, is happening. He's saying the policy is quite useless. There was no need for a CBW. That is, gives no service. He'll come to all that. Whether the policy was needed or not, that comes later. Question is first, how are you affected? So kindly see the margins. I would only invite my lord to go through these 7, 8, 10 pages, and second last column, kindly see the entries. It's very fundamental to the initiation of the case. Lordship takes page 1, for example. 0000000. Second last column. Some rebuttal should have come to this, with great respect.
Notice was not issued.
And my learned friend said notice is not issued, and therefore there was no need to rebut it. Very well, your lordship will consider that, whether there was no need to rebut it. Fact is, it has not been rebutted. And since that is the stand being taken, your lordship will kindly formally take note of this and the fact that they have not sought to rebut it. I have no difficulty if they rebut it even today. No difficulty. Let them do so. Kindly see the next page. Similar 00, sometimes minus, goes on here and there. I think 2% is the maximum I can see offhand. Kindly see the second last column on all these pages.
Yes.
And if there is a technicality, kindly formally issue the notice on this petition, take it on record, and record that nothing, and then whatever they have to say, they may say. But such an important point, which goes to the root of the argument, If it is an incorrect statement, my lord, it is not merely for me to point out, but it is with respect the duty of the court to take note of something. If you have said you are paying 17% and I am pointing out that you have paid nothing, then the court has to take notice, my lord. It's not good enough to say notice has not been issued. Lordship issues the notice with respect. If that is the issue, there's an application. Notice has not been issued, so I am not required to rebut it. So your lordship kindly then directs them to give a rebuttal to this if there is a rebuttal. But at the moment, this is the figure, and this is the figure affirmed by the Commissioner of Excise, no less. And with respect, I must say, in fairness, Mr. Shah never talked about notice being issued and not being issued. He had an argument which I am putting before my lord. His point was, because he had this before him, he never took any objection saying this cannot be relied on and all that. His point was that, I'll tell you what he said in answer. His point was that because of the pendency of this writ petition, the arrangement between the supplier and CBW is that CBW will not charge any margin so long the matter is pending in the court. This is the argument with respect, my lord. I really don't need to... an organization functioning for 4 years and you say that margin is not required, we need not bother about the margin. And your main argument before the court is that margin is being extortionately applied. Then come after when the margin comes to 17%, come to the court. At the moment, you have no cause of action. This period is covering till which year? Recent. 2025, February, right? So up to 2025 February, it appears that no margin, extortionate or otherwise, is being charged. Why it is not being charged, whether it is being made up by extending credit periods, whatever it is, I do not know the internal arrangement. But the fact is, the record shows margin is not being charged. Lordship kindly formally takes note of this and the fact that the argument was that it is not being charged because of the pendency of the petition. Of 4 years, my lord, that cannot be an argument. And if it is not being charged, then why, with respect, that 17% was only notional? This was a letter. So it was never charged. So my point before this court is very short. When it is charged, when you face that exorbitant 17%, then you come to the court. Because as your lordship sees, the letter says negotiation. Negotiation could be 2%, 3%, 5%, maybe more, maybe less, could be anything. So when it is charged at 17%, come to the court. You say 17%. When I come to the court, I show your lordship that there is in fact charge is 0. So that's the first point.
Yes.
And I should just point out in passing that when we are talking about negotiation, one should have some idea of the weightage of the petitioner group. The petitioner group has some of the biggest international names in the liquor industry. Pernod Ricard and Diageo. I think Diageo was probably the largest or second largest in the world. These are world leaders. And so far Meghalaya is concerned, they have, I am told, roughly 40% of the market. I am instructed. I have not put it on record. And we have given the industry report here. Where is the report? I think, yeah, 142 now. Somewhere there. Yes, if your lordship comes to page 145 of the same.
On the last occasion,
yes,
you said 50 to 60%
of the Indian market.
liquor supplier in Meghalaya.
Well, 50 to 60. I stand corrected. That's right. And Indian market, your lordship comes to page 145. 145 of this same petition. (145). Right at the end. I mean, not right at the end, but 10 pages from the end. 145. Lordship has it? Market share of the top IMFL players, the chart. So United Spirits 23%, Pernod Record 18%. So these are the two of the players here. Roughly 41% of the Indian market is theirs. So what I'm saying, they're dominant force. Now, why this is important, I tell your Lordship, whether 40 or 50%, I am no other player in the market comes close to matching me in Meghalaya. I am the big boy. Now, I have therefore massive negotiating power with CBW. In the worst case analysis,
You're the bonded warehouse.
no, I'm saying with CBW, I should not say this, the supplier, as between supplier and CBW, supplier has massive negotiating power. Because CBW has to get its stocks from the supplier. Supplier controlling 41% of India's stock, 60%, 50% plus of Meghalaya's demand. So they can really lay down terms which more or less to their liking. It's not some weak player with the monopolistic CBW holding control. If CBW wants to store and sell the liquor in the state of Meghalaya, it must come to reasonable terms with the supplier. Because tomorrow, what is Meghalaya in the national context? It may, I do not know the figures, but the liquor supply may be 5% of India, 3%, 4%. I mean, theoretically, this ISWAI group can even shut down the entire liquor and still not make much of a dent to its profit. They are in a very commanding position, I'm saying. So, negotiation is a negotiation not only between two equals, but between the dominant player in the industry. So, one should not have any great sympathy on the basis that, look at this poor little supplier and this massive CBW squeezing them by the neck. It is not that. That's not the reality. And that is reflected in the fact that they have been managed to be able to get their goods stocked with CBW with zero margin, which I have shown to your Lordship. So my question before this court is, which I am posing to myself before this court is if you have not demonstrated that you are suffering a loss on margin compared to what you had earlier. Earlier, my margin was this. Now after this policy, my margin has gone up to this. The minimum they should have indicated to your Lordships. That look here, prior to the old policy, this was my margin. Now I am having to pay this. This has not been proved. Rather the contrary. Then the question is, would your Lordships go further into the discussions of policy, private monopoly, etc.? This is my first question your Lordship would consider. The gateway, the threshold. Until this is answered, that I am going to incur this additional loss because of the new policy by the new margin, then they have not been demonstrated to incur any loss at all. So then why is this court for academic discussion going to go into this question? This is the question your Lordship would consider. That's the first point, my Lord. I have made this question. No, I stand by that. Now then, without prejudice to the same, if your Lordships are with me on this, that there is no financial loss, of course, all other matters become ocios. But I will, of course, answer them all. Next question, my Lord, is the question of, my Lord, what has been argued is that the policy is beyond the power of the state government. Lordship may recall the argument regarding Section 19 of the Act. So may I place, my Lord, this manual? I'll just take the exercise manual. I'll place the various sections to show what is the power under the law for the state to enact delegated legislation so that a central bonded warehouse can be established. Because this, in fact, this I would say is the only legal question which has been raised. The others are not all speculative. This is a legal question. So, I will get into this manual, brother. See if he's got it. I'll have to go to the rules and all that later. No? If your Lordship comes to the Assam Excise Act, if your Lordship takes it. Technically, you should have a manual. Is there? These rest of it? It's all there. Okay. No. Amended rules, everything is there. My Lord, may I proceed with the provisions of the Assam Excise Act?
Yes.
My Lord. So, I appreciate your Lordships have been shown this, but then it's, from my point of view, it's my duty to show this. So, the preamble, because it has been argued that under this Act, I, the state, have no power to create this policy. So, therefore, I have to show your Lordship the various provisions which empower me to enact this delegated legislation. My Lord, the preamble. Whereas it is expedient to consolidate and amend the law in force in Eastern Bengal and Assam relating to the import, export, transport, manufacture, sale and possession. Kindly note the word possession.
Yes.
So possession is included. So warehousing is a species of possession. That's the preamble. In the most general terms. So after your Lordship notices the preamble, this foreign liquor definition I'll have to show also later on this chart. This foreign liquor one with the diagram, where is that one? The diagram for this I'll have to show. Make sure you can get it out for me. Now kindly come to definition clause, section 3. My Lord has section 3?
Yes.
So, I'll come straight away to section 3, subsection 12. Import, except in the phrase important means to bring into the territory to which the act applies, otherwise than across a customs frontier. So, bringing into Assam, now Meghalaya, from outside Meghalaya, will be import. Intoxicant means any liquor or intoxicating drug. My Lord, intoxicating drugs then are defined. This is all going to be important in light of section 19 argument. So, I'll come back to that. But intoxicating drug means leaves, small stalks of the hemp plant. Basically cannabis, bhang, gaja. Then B, charas. Resin obtained hemp plant. 3, any mixture of these. 4, any other narcotic. So, clause 13, at least in that regime, governed also ganja, cannabis, bhang, charas, all were governed under the heading intoxicating drug. Lordship sees it. Why it is important is I'll come back to section 19. All this is covered by section 19. Then 14. I'm going a little slowly here. Liquor. We are concerned with this. Liquor means intoxicating liquor and all liquids, etc., etc. Also, adi and pachwa in any form. So, liquor is All types of liquor, intoxicating liquor. Maybe whiskey, maybe pachwai, all. All of it is liquor. Then pachwai, 16 means a fermented rice, etc. I'm not taking a lordship. 20, tadi means juice from the palm tree. These are all country spirit type things. Then, paragraph 4 is very important. Power to define country liquor and foreign liquor. The diagram. I have it, but yes. Now, paragraph 4, clause 4 rather. Power to define country liquor and foreign liquor respectively. The state may by notification declare for what purpose, for the purpose of this act, shall be deemed to be country liquor and foreign liquor. Now this is very important. What is country liquor? What is foreign liquor? My lord, that definition has been done by an order passed under the Excise Act. My lord, I have the diagram. My learned friend is finding it from your... How do you show it? How do you get it up? Getting a copy. Anybody give it to me? How will judge this? I've told you. You can hand over that thing to the judge. Well, I'll take that. You can. You don't have to hand over this manual. This is in your lordships in the excise manual, but if I can just hand it over to you all. You have another excise manual around? Yeah, but then how will the judge see this? Just for a moment, my lord, may I hand over this?
Are you here tomorrow, Mr.
Yes,
Pandey?
yes.
We'll continue tomorrow.
Very well. I'll get a photocopy of this done tomorrow. I'm obliged. Lordship's keeping it as the first matter.
Yes.
I can start at 12 or whatever time your lordship.
Only matter. And if
I'm
time permits,
grateful.
other matters.
The lordship is a little under the weather maybe today. I think your lordship's.
Bad cold.
Oh, yes, I can see that.
Yes, please take them.
For that thing which I get very commonly, there is no cure known to medicine other than rest and maybe some nasal inhalations and things, but nothing really works. Except
It works a little bit for me. Homeopathy works.
homeopathy works. That is the only, allopathy is the only,
But you have to get the correct medicine, and 99% of doctors will give you the wrong one.
wrong one. Yeah, that is true. But homeopathy, otherwise there are other practices like yogic practices for the, all those things, sometimes they work also. Those nasal things, but very difficult on the long run to cure it.
No, with a medicine called arsenic alp 30.
Asana 30, yes, yes.
I think I was able to ward off COVID.
That's a great achievement.
I don't know whether it was
No, that,
natural or because
I
of
do
that.
use that, but I didn't know whether it was effective for COVID. Of course, that.
So during that time, they said you have 2 to 4 drops at bedtime, and
That worked.
And try.
That worked.
Heard Mr. Deval Kumar Banerjee, learned senior advocate, appearing for the
State of Meghalaya.
appearing for the state in all the matters.
In one matter, I am appearing with
Both the matters.
in the list.
On the notification.
One notification also.
And then tomorrow.
Yeah.
Should I indicate today? No point. Make sure you have it. Okay.
Mr. Banerjee is appearing in item 1, item 2 I am appearing.
Take the floor.
So first, item 1 has to be concluded, then thereafter by chance will come in item.
In that item number 1. Arguments are not concluded. List this batch of appeals for further hearing tomorrow, bracket 11/7. Yes, Mr. Pandey.
Yes, Lordship, that miscellaneous application, Lordship has granted liberty. to approach this honorable court after the process is over for appointment of second bonded warehouse, my lord. So we have moved the miscellaneous application. I was praying that this application may be taken up tomorrow, my lord.
All right. But you filed it.
Yes, I have filed it, my lord.
All right. List. Upon mentioning pleading urgency, list miscellaneous application so and so, along with the above appeals tomorrow.
Grateful, my lord.
May I crave your Lordship's indulgence? Lordship, item number 15, I have actually travelled from Guwahati, so if a date could be fixed as per the convenience of the court. This is that Weybridge matter, Lordship.
Weybridge matter, my lord. We have filed the affidavit.
Lordship, affidavit has been filed. It is to be taken up for final hearing.
You were here yesterday.
Monday, Lordship. I was here on Monday.
Monday. See you here on Monday.
So if you are here today, we can take it up tomorrow. Or you take another date.
Lordship, if it could be on Monday.
Monday is holiday.
This is a holiday.
Tuesday or Wednesday, any date as your Lordship feels convenient.
Item number?
15.
Okay, may have it on Tuesday, my lord. We will assist your lordship on Tuesday.
What is the position?
Your lordship, we have the way bridges across the state, my lord. I will place everything, my lord. The reports, audit reports which have been shown are the audit reports from 2012 to 2022, my lord. In audit reports, your lordship has dealt with a license disputes where licensee has not paid. So averment was made that the huge loss of revenue is taking place, my lord. I will show, my lord, everything. Your lordship have it on Tuesday. We'll place all material in that matter.
No, your report said that
There is no overloading of trucks.
Yes, we have.
That
your
is
lordship,
what the state
I will
government
let me place my report. My report is, my lord, that whenever there is a overloading, we check it and we challan it, which is across India that is happening, my lord. And the petitioner, my lord, he has travelled and checked
across India means you're for the state.
I am for the state, my lord. What they say that there is a overlaid. There are some vehicles which are overladen. My lord is aware
all
that
those states are following this practice.
States are, and we are checking wherever the vehicles are overladen, we challan them, my lord. That is under the Motor Vehicle Act, we take action, my lord. So far as revenue collection is concerned, my lord, Motor Vehicle Act provides for challan in case vehicle is excess of its weight prescribed in the registration certificate, my lord. That is, and it is not meant for revenue collection, my lord. It is only for the purpose of collecting fine on the overladen vehicle, my lord. That is the thing, my lord. Lordship I'll show, my lord. I have filed a detailed report. I have personally gone through. Lordship may have it on Tuesday.
No, it has a dual purpose because you may be content with collection of fine.
Yes.
But then if they're allowed to pass,
Yes,
if they're allowed to pass without checking
Yes,
or
ma'am.
insufficient checking,
Yes, ma'am.
then there is also loss of revenue.
So the case is not that there are two-tier mechanism which is taking place for checking, my lord. One, when they enter into the state, they are checked, my lord. They exit, they are checked by the custom authority. And there are two-tier. One is the check gate set up by mining department, so far as mining produce is concerned, and one is by motor vehicle department, transport department, my lord. So there is a checking separately for mining department, and there is checking separately for transport department. As a matter of fact, we have got a letter from custom authority saying that not a single vehicle is allowed without weighing the vehicle in Bangladesh, my lord. That letter I have also annexed with my affidavit, my lord. So there is absolutely no difficulty, my lord. I will place and I will show from the
No,
affidavit.
apart from that, we are interstate also,
Yes,
intra-state also.
Yes, my lord.
They will avoid GST and all that by
Lordship, so far as GST is concerned, my
by
lord,
undeclared quantity of goods.
no, because, my lord, we are not as such. GST is concerned, my lord. We GST, there is a separate mechanism to levy and collect GST, my lord. The problem areas which we face as a state, my lord, are twofold. That minerals are illegally mined like coal, etc., and they are taken to the other state. There we have got a special mechanism. Even court commissioner, court officer in the form of Justice Kataki has been appointed to oversee all these measures, my lord. So, and wherever he finds anything amiss, immediately the officers are taken to task, my lord, in those matters, and the coordinate bench is reviewing those matters in
Yes,
court.
what do you propose to do?
Lordship, final hearing, because in the latest report also by which the list of weighbridges were given.
Have you taken an exception to the report? Have you filed
Lordship,
a counter affidavit?
Yes, Lordship. I have already filed my affidavit to the report.
No,
And in response, yes, I have already served. Mr. Singhon has filed a response to
madam.
the same.
Just give that brief.
When will you file? After this, you file the response. Yes, 8th May, response was filed, my lord.
And
By the
11th June, I have filed my response to the status report.
What have you
11th
said?
June, I have filed the,
11th June is my affidavit.
yes, and then thereafter, in response to 11th
In
June, I have filed.
response to 11th June affidavit, the secretary has filed an affidavit.
My lord.
Lordship, the state government, in one report they say there are 19 way bridges, in another
I will
RTI
show
they say
that
there are
those way
20
bridges
way
are in
bridges.
existence, my lord.
In
Those way bridges are in existence. And numbers are licenses
different.
licenses are
Lordship,
cancelled,
I may be
and then way
permitted to
bridges
submit-
is removed, my lord.
Lordship, the number of way bridges keep on changing at every single stage
No.
as to how many way bridges are there. In the RTI they say 19, in the report they say 20.
We'll place everything, my lord.
In the inspection,
how many
they
way
say
bridges we
24.
have? Because way
Everywhere
bridges
it's
number
different.
increase or decrease depending upon licenses, my lord.
And secondly, with regard to way bridges which were yet to be functional,
Court order.
way bridges which were yet to be functional in 2023 are still yet to be functional. It is an admission of the state.
I'll place, my lord. The petitioner is interested in way bridges or in extortion. Because
Lordship, where is my
petitioner has
extortion
filed the PIL earlier, and on the same issue, not a single averment, not a single line in second PIL.
Lordship, in
He's
the
a
second
politician from
PIL,
Garo Hills. He's interested in
Lordship,
he's a politician from Garo Hills. He was caught intimidating election the voters also, my lord. I'll place all those materials. And your lordship directed him to inspect all the way bridges. He refused to inspect the way bridges in Khasi Hills area, saying that he has a threat to life, my lord.
yes, Lordship, he
He
did not
has
visit
said
Khasi
this
and
was not
Jaisalmer.
argued, this was not said when the order was being passed. And without that, because he conveniently ignored.
That is
Where
why
is
he
the latest
informed us.
order? This is 25. Before that? These orders must be properly arranged chronologically. You have filed any counter affidavit?
Yes, my lord, we have filed detailed counter affidavit to the PIL, my lord.
And you have maintained the same stand?
Yes, my lord. And we have, and time, your lordship has directed if your lordship will kindly see the order of your lordships of 16th May, my lord, 5th December, my lord. 5th December is the order where lordship has took cognizance of the matter.
Yes.
And your lordship at the page 2, my lord, page 2 at the bottom, my lord, and we pass the following interim order at page 2, my lord. A spot inspection for 2 hours will be conducted by the respondent in the presence of petitioner and his representative in each of the weighbridge at checkpoints on one day at a time when vehicular traffic is greatest. Such inspections shall be incognito, that is to say, without making any public announcement. We clarify that only petitioner is to be informed and who shall keep the inspection secret. Petitioner shall not conduct any inspection but shall be present only. An overloading fee, charge, revenue, etc. realized of such inspection shall be stated in report and submitted before the court.
Yes, we have seen that, Mr.
Yes, lordship. So we have carried out the inspection, but the respondent has not carried out the inspection in remaining areas, saying that he has said, but my lord, on the merit of the case, my lord, I will show on the merit, my lord, there is nothing in this PIR. There is nothing in this PIR.
Yes, please take down. This public interest litigation is about operation of way bridges across the state. The allegation of the petitioner is that in the 28 way bridges which are said to be operational in the state, the carriers and the government officials are involved in illegal activity full stop. Goods vehicles are allowed to pass without proper payment. In many places, the way bridges are non-functional. There is corruption, full stop, comma, resulting in loss of revenue to the government. Paragraph by our order dated 16 May 2025, we ask the government to file a report. Now, by our order dated 16 May 2025, we ask the petitioner to respond to the report filed by the government stating that it had carried out inspection in 24 way bridges and found that in none of them any overloaded truck was allowed to pass. It also added that in international transit between Bhutan, India and Bangladesh, the level of control by the Indian authorities was minimal. Paragraph, the petitioner has taken an exception to this report. The government was asked
to file report. Fourth July report is there. 4th July. It was filed on
asked by
4th.
our order dated 4th July
Yes.
to respond to the objections taken by the petitioner. Another report has been filed by the government which states that it maintains its stand that there is no irregularity or illegality in the payment of goods vehicles across way bridges. Paragraph, the public interest litigation is now ready for hearing. Ms. Agarwal, learned advocate for the petitioner, does not accept this report of the government. Full stop. Her client is directed to file a further affidavit in more detail as to how he is aggrieved by the report of the government and in what respects the report is erroneous. Short of the necessary details, it would not be possible for this court to adjudge the merits of the allegations made by the petitioner. Such affidavit in response should be filed by when you will file?
If it could be by the
Take the whole month.
Lordship by 1st of August, we'll try our best.
By 1st August, list this public interest litigation on 5th August. At the time of correction, you send this order file.
Deeply obliged, Lordship.
Please don't mention they will be carried forward tomorrow. Single bench will sit immediately. Yes, Mr. Paul.
My lords.
But these matters
Have you found out regarding that?
but I was praying for some time, my lord, in these matters.
It's very important
Yes, ma'am.
because if in 482, if it is found that the charges do not disclose any offence,
My lord.
then we have to pass an order of discharge. Then would it be possible for the prosecution to initiate the proceedings afresh with new charges?
But I was praying for some time, my lord, your lordship.
My lords, we'd also do some research on this and get back to my lords on this. I have to try and assist my lords on this issue.
Because Article 20 says that no person shall be prosecuted. Please come to Article 20.
Give me the Constitution. Get me the Constitution quickly.
No person shall be prosecuted and punished for the same offence more than once.
Yes.
So prosecuted also comes on. But the word used is and. So we will examine, my lord, what is the purport of this and in between, my lord. Prosecuted and punished.
Principles of double jeopardy, my lord.
The provisions CRPC also.
Sir.
CRPC also
Also
does
there
similar
is.
provisions. Section 300 CRPC also.
See, one is prosecution, then punishment. Say, for example, prosecuted and punished for 3 years. Then the prosecution realized, no, I've got more evidence. It's worth punishment, life imprisonment. So I will initiate another prosecution. You cannot do it.
No.
Yes.
But suppose there is prosecution resulting in discharge, then you perhaps cannot prosecute again.
Principles
Because
of
then
double
all
jeopardy
discharge
come.
cases would be met with fresh prosecution.
Lordships.
What I feel, my lord, once discharged, there cannot be, only if the court directs further investigation or fresh investigation, my lord, only in such case a fresh charge sheet can be submitted. But once it's discharged, I think that will then
No,
matter,
as long as the charge sheet is there,
my lord.
the prosecution makes an application that I want to file a supplementary charge sheet.
Yes, my lord. That is
That is all right.
That is permissible.
But if the charge sheet, the foundation of it is
Struck off.
flawed, and it is set aside by the court, that it doesn't disclose any offence.
In such case, in my humble submission, my lord, I'll look up for some decision, my lord.
I would
But it appears that
recommend my
that will be the end of the
that
matter.
would be the end of the
important.
matter.
That will be the end of the matter, my lord.
Because here, it's to put it very simply,
My lord.
the charge is interpolation. Interpolation, changing the marks
My lord.
so that the result is changed.
My lord.
Some favored candidates are selected. All right.
Yes, my lord.
Now, that particular accused is involved either in commission of that or aiding and abetting it. That has to be there because that tabulation sheet, as shown by learned counsel, has been signed by 5 persons. That is my recollection up to now.
This is, my lords, what I wanted to point
Here,
out.
what
today.
happened, my lord, after the tabulation sheet was signed, my lord, then there were manipulation by
Well, it's-
in that, my lord.
Here, there's something even more interesting. What I wanted to place before lordships, that the 5 people, my lords, who were there in that selection committee, they say we have submitted the original score sheets to A2. That's my client, my lords. Now, CBI goes and seizes a copy of the so-called select list signed by all 5 of them from one of the members of that select committee. they treat that as the original, and on the basis of that, my lords, they come to a finding that there is interpolation of the
Mr.
original.
Paul is the merits of the matter.
My lords.
And at the time of trial, all these things will be proved. But the thing is that there must be a specific charge against.
But, my lords,
so-and-so.
which is what, my lords, I can only forge something which an original of which is undisputed. Now, on the basis of a photocopy, my lords, obtained by somebody who's not supposed to have a photocopy, they treat that as the original, and a charge, my lords, of forgery is made against me.
No, that at the trial, Mr. Paul. At the criminal trial, you will say that this is not the original, this is not the document, etc. 482 court may not have
My
anything
lords,
to
that's the admitted position. They say that this is not the original. They say that he has taken out a copy from his pocket and he shows it, and the CBI treats that as the original. For any forgery, my lords, there has to be an original which has to be forged.
So, in the absence of a specific charge against the minister or the director, that the minister herself or himself with
E2, my lords,
with
the
a
director.
white ink in her hand and a pen in another hand has erased the marks and inserted another marks, etc., etc. How is a criminal thing?
Well, as far as director is concerned, about A2 is concerned, there are clear allegations of that. That benefit, if at all, my lord, may be available to A1, my lord.
No, but if
Departmental proceedings may lie, but how a
criminal charge.
Mm-hmm.
criminal thing will lie?
Because here what happened, my lord, the entire investigation was under the directions of this honorable court, my lord, passed in the writ petition. The matter travelled to Supreme Court.
Well, it's on various occasions, but that, my lords, would not have a bearing. It culminated into a direction by this honorable court that you investigate. If the investigation is flawed and the charge, my lords, cannot sustain itself, that you cannot take the shelter that merely because this court has directed investigation, it would be saved. The lordships are examining that.
I'll come back, my lord. I'll grant you
Please, because
10 days time, my lord.
my days are limited here, so I have to finish this matter off instead of shoving it on some other judge.
My lords.
My lord.
So you next day where we can give more time, please mention
My lord.
when.
A week's time, my lords. We can have it next week, subject to
No,
my lord's
next week, I have
convenience.
some difficulty. My lord. I was thinking of traveling next week. A week after that, my lord.
22nd, 23rd, or
22nd.
No, that week I'm traveling.
July.
The week,
July.
sorry.
July.
Yes. That week starting from 21st, any day. my lord.
22nd.
Yes, hearing of this application continues, but it's not concluded. List this application for further hearing on 22nd July at a time to be specified in the cause list.
My lord.
I'll reply.
And